about that. She
Okay,
said, I've
yes, sir.
seen it.
Yes.
Who it is and what it is, we don't know.
All right, Your Honor. That's all I have for Ms. Warman.
All right, thank you very much. Read a record.
Yes, sir, Your Honor. I was looking for what was marked as a defense exhibit so I could show it to her again.
Yeah, you need to
That
leave.
conversation.
And we need to have defense 5, which was marked up there too. There's no questions other than it was shown to her and she said she had seen it.
Thank you, Judge. Do you remember seeing this from Mr. Truslow? I'm showing you now defendant exhibit number 4.
I do.
Okay. And what you talked about, is that the complete conversation on that page?
It looks like it might go on.
Okay. If you don't mind, why don't you tell the jury the rest of the conversation on that page?
Okay. It starts with Heather saying, "Do you have a phone yet?" Dennis Hart responds, "No, I haven't got any money yet, ... Heather responds, "Oh." Dennis responds, "I'm trying." Heather responds, "I've gained so much damn weight lately, WTF, what the fuck?" Heather responds with a stick figure that is ejaculating. Heather responds with what looks like a blank text. I'm not really sure, it might be an emoji, it's just a square box. Dennis responds with, "What the fuck, haha, and I doubt you gained that much weight." And then it says there's a text after from Heather, but there's no continuation.
And what is the date on it?
That would be 11/24/2013.
Okay, and she's talking about gaining weight?
Yes, she is.
And do you know Dennis Hart that she's talking to in this conversation?
I do. I was present during this conversation.
Okay. And if you don't mind, tell this jury, is this Dennis Hart, did he even live in South Carolina during this time?
No, he did not. This is Dennis Jr.
Okay. And did he live in South Carolina in December of 2013?
He did move back after Heather went missing. I don't know if it was December or if it was January. He had lived in Myrtle Beach prior and then had moved to, I believe it was his mom's house for a couple months.
Okay. And okay, so he wasn't even living here December 18th of 2013.
Lady.
Out loud, right.
Was he living here?
No, he was not.
Okay. Now, he also asked you some questions about Dennis Hart Sr. Do you remember that?
Correct?
Okay. When she called you, did she mention anything about Dennis Hart Sr.?
No.
Okay. And were y'all together every day in December of 2013?
Until I left for New Jersey.
Okay.
Yes, ma'am.
And was she seeing him in any sort of romantic fashion?
No, ma'am.
Was she even seeing him outside of work?
No, ma'am. She was friends with his wife.
Okay. Did they text or talk on the phone?
Senior or junior?
Yes.
Senior? No.
Okay. So this was somebody she never even had contact with other than they worked at the same establishment?
That's it.
Sustained objection. Disregard the last answer if you want to rephrase your question.
No further questions.
Well,
No further questions, Your Honor.
thank you. You may come down. Then you can leave all, leave that right up there. Thank you so much. Do you wish the witness to be excused?
Yes, please, Your Honor.
Any objection?
No objection.
You're also free to leave. Thank you very much. Have another witness?
Your Honor, this time the state rests.
All right, ladies and gentlemen, kind of anticipated that. We had a discussion earlier about that, and it comes at a good time. It's a lunchtime. And there's some matters of law that I need to take up out of your presence, so you're going to get the benefit of a little break tonight. Today, you're going to get to go for an hour and a half again, and we not, you would. please be back in the jury room by 2 o'clock to resume the trial at that time. Please remember, you're not at liberty to talk about this case among yourselves or with anyone. Have a good lunch and I'll see you at 2 o'clock.
This is an exhibit, and Kurt, this is yours. Thank you, sir.
All right, any motions from the state at this time?
No, sir, Your Honor.
Mr. Truslow,
Yes, sir.
happy to hear from you.
Your Honor, defense is moving for the directed verdict on the charge of kidnapping. As a backdrop, I would like to say that I am certain that Your Honor is familiar with the law in this case and in this issue on circumstantial evidence.
Has to be substantial circumstantial evidence.
Yes, sir. And what I want to say before I discuss one case in particular is that it's my understanding as I read the cases that I'll cite into the record that there's been a pullback in our appellate courts in terms of restricting some of these cases going to trial, and it appears if you read these cases, many cases will go into trial to a jury that should not. Over the last few years, the court has tightened up on that because the overriding concern has been not putting a jury in a position where they have to speculate or guess.
I understand.
So, in this case, Your Honor, and I would like to quote State v. Arnold,
Okay.
351 South Carolina 302. I'm going to provide that to the state. And this discusses, I'm not going to give you every case that there is because I know you're familiar with it, but Your Honor, in this particular case, applying the facts of my argument to the law as it's stated in here that I know you're familiar with. The evidence in this case, or excuse me, the indictment in this case is that my client kidnapped Heather Elvis. The statute is very clear. It's a very small, short statute. I think it's about a sentence long. But in essence, it lists 5 or 6 words. One I always have trouble with is inveigle. But in other words, they have to prove beyond a reasonable doubt that she was kidnapped and that Mr. Moorer kidnapped her. And there has to be enough evidence to allow this jury to reach that decision. In this particular case, we have evidence that my client had an affair with Heather Elvis. We have my client making a phone call to Heather Elvis. And I'm going to argue this obviously in the light most favorable to the state, as we must. In the light most favorable to the state, he called her and told her that he loves her and wants to be with her. Then we have a series of calls they introduced from Heather Elvis to the payphone, presumably trying to get back in touch with him. And then there are a string of calls to his cell phone. Now in this case, and I'm going to go by that piece by piece. In terms of those phone calls, there is evidence that that phone number is associated with a phone used by Sidney Moorer. There's not evidence that Sidney Moorer had possession of that phone when it was being called. In fact, the only evidence surrounding the night of this incident or any time before was that he used a payphone instead of a cell phone. So there's no evidence that connects him with using that phone or receiving messages or missed phone calls on that phone outside of the fact that his name is associated with that phone. And in fact, there's testimony in the record that, well, that's for the jury. The next issue then, Judge, is Heather Elvis. Her vehicle was located at Peachtree Landing. I don't see any evidence really as to, the evidence of how it got there is evidence following her mobile phone. So if you assume that her phone got to Peachtree Landing, you can presume that she drove to Peachtree Landing. Jumping to the next issue is the video evidence. The video evidence in this case, Your Honor, is that a vehicle, and I'm going to start with that, drove down in the direction of Peachtree Landing. However, in the direction of many other places as well. And then a short time later, a vehicle drove back by. Now, there has been evidence presented that, and again, in a light most favorable to the state, which you have to judge what was put out there, that an expert testified it was a Ford F-150, and he further went on to testify that it was his Ford F-150. The evidence that's lacking to go forward to a jury and to put this jury in a position where they have to engage in guesswork and speculation is, number one, did that truck ever go to Peachtree Landing? Because it could have turned left and went out to 544. It could have went another route and went into Socastee. But most importantly, Your Honor, in an overview of all the evidence, Sidney Moorer was in that truck at the time, I believe, around 1 o'clock, 12:30, it appears, at the Walmart. Now, skipping ahead to 3:40, and in that time range, a.m., some 3.5, 4 hours later, or 3 to 4 hours later, there's no evidence that he was in that vehicle. None. There's no evidence that he is driving that vehicle, a passenger in that vehicle, other than it's his vehicle. And for this jury to convict him, they will have to guess who was in that vehicle. And I think it's right on that line that it just doesn't rise to substantial circumstantial evidence. Because one of the other issues in this case, and in looking at this law, it says you don't have to eliminate all other possibilities. However, the case law does engage in some limited looking at, well, you know, when they're looking at it for this issue, how strong, I mean, how well likely is it that these other things could have happened? Now, whether Tammy Moore was driving that vehicle is just as likely, if not more, because she's been threatening and sending pictures and everything else we've heard of this trial. Stephen Schiraldi, who said he dropped her off, gave her a kiss, went home, called her one time, told somebody else he texted her up until 3 a.m. We don't know where he went, what he did. Then we've got a period of 30 to 31 minutes where Heather, in the middle of the night, is, or at least her phone, is in the vicinity of Longbeard's bar and restaurant. We have no idea what's going on there. But what it all comes back to, Your Honor, is simply there is no evidence, or not substantial circumstantial evidence, that Sidney Moorer went to the boat landing, or that he was in that vehicle. In addition to that, there is no substantial circumstantial evidence that Heather Elvis ever entered a Ford 150. There's no evidence that the Ford went down there, and if it did, if Heather was even there or had gone somewhere else by then. There's no evidence of whether she got into the, whether if somebody did go in that Ford 150 and pick her up, whether she was forced into the truck or tricked into the truck. None. If she voluntarily got in the truck, then somewhere along the line, in order to prove it was kidnapping, you have to prove that she was, at that point, not permitted out of the truck. And certainly nothing happened in the truck because they searched the truck the day after. And in this case, we have, obviously, because we're already substantial circumstantial evidence, we have no forensic evidence of a hair of anything in the truck or her car. And for those reasons, Your Honor, I truly believe, and I point to that because we've been here 4 days. So it would appear that there is a lot of things because we've had a lot of witnesses. But in this case, there's been so many witnesses that I didn't even have to ask questions to. There were chain witnesses or said that things that just didn't really weigh on the issue, more or less. So what I've tried to do now is break it down to you. Out of all of that, it's some phone calls and the truck going back and forth. Who was driving the truck or present in the truck on the way there, there's no evidence of that. Or certainly that's not substantial circumstantial evidence. When you live in close proximity to your family and with your family and other people that can drive a vehicle, how do you show that it's him? It's not substantial circumstantial evidence. And then the following elements, everything that happened thereafter, there is no evidence of whether she drove off voluntarily with this person, whether after then that she was restrained or let go. We do know that Heather Elvis is not here in the courtroom today. And that they did not have activity with her phone. But, there's a lot of explanations for that too. Maybe not explanations that a lot of people would buy, but there are possibilities that could happen, and that's our argument, John.
Well, I appreciate that. The evidence, I agree with you, has to be, this is obviously a circumstantial evidence case, and what I'm going to charge the jury, we've added, we took it out and then we put it back in. Then I'm going to charge the state has to prove the basic circumstantial evidence and direct evidence equally weighted. But as to the circumstantial evidence, the state has to prove each one of the events and circumstances they're relying on beyond reasonable doubt. Further, that the facts must point conclusively to the guilt of the accused, and they must be wholly, perfectly consistent with each other in every particular respect. And you're right, there are probably a million what-ifs and could-bes, but is there a reasonable connection to the state's position and the light most favorable to the state, which I'm required to do at this point? I have a couple that was having an affair, obviously, and a decision made by one of both, the benefit of the state, it was by him, to break it off. We have, and again, what the jury believes and who's texting. There are a lot of texts. It could be from him, could be from his wife. The jury has to make that conclusion, but in light most favorable to the state, there's some animosity possibly existing, but probably the underlying principle that just simply is, and this is absolutely the most heinous thought that I can imagine in this situation. But is it a logical conclusion? Has it ever been done in the history of the world? You bet. I want to get back with my family. You're pregnant. I know how to get rid of that. And therein lies the issue, in a nutshell. And having seen where that is, I notice there are cajillion places where a body could be disposed of and no one will ever know. And I'm not suggesting anything that would be a conclusion I'm not capable of making. I don't know anything. Only thing that I know, it is totally inconsistent for a young lady who was as active and involved as she was, and who testimony said was excited about her life, and to suddenly just vanish from the face of the earth because she chose to just disappear. While that's a possibility, that's not logical and reasonable, and that's what we talk about, a reasonable conclusion. So to me, that doesn't even enter into it. Another factor that weighs heavily, of course, is the fact that it's a new truck, number one. And the testimony is that never saw anyone but him drive his truck. That doesn't shock me. I know some people, my son being one, he's extremely careful about his vehicles, and a lot of people are. I don't know whether he is or isn't, but there's a logical conclusion that he is. It's a nice vehicle. It's been, whether I grant you, the jury's going to have to make that call. And obviously the testimony of the witness, and we talked about that in the previous ruling, and he confined it to his experience, and you examined him. There are other opinions maybe out there, and there's no question about that. But taking it in a light most favorable to the state, we have his truck. And we have his truck going to this remote place. And then we have the circumstances which I think gravitate towards, now granted, there are some other people that have been suggested, but no other trucks coming at the time that everything stops. That's important to me for my conclusion, because that's where we get into something happened in this time frame, and that there's no question that that truck is at least in the area. Who's the person that saw her? Well, first of all, how is she there, number one? Why would she just pick this spot? There's a telephone conversation. We know there's a subsequent conversation with with the phone. To whom they're talking, we don't know, but when the light most favorable to the state, they're talking to each other. And it's suggested, let's meet there. And the way the car is left, it's locked. There's a driver's license still in there, which means the person anticipated probably that I'll be coming back. And the logical deduction from that is I'm coming back, I've got my keys. No keys have ever been found. And probably the most critical thing, and I think this is an extremely connecting circumstance, the cell phone is gone. Why would you just take your cell phone if somebody's come there that you didn't know and snatched? Why wouldn't there be some evidence of something happening? Why would you take the time, somebody's come there that you didn't know and just suddenly abducted you? You would methodically take your phone and lock the car? That doesn't make any sense. That doesn't ring true either. So the obvious is the logical conclusion, it was somebody she knew, somebody she didn't mind seeing. And that leads directly to him. My conclusion that and what happened? Was she kidnapped? I think the argument is that we're not a res ipsa state. I don't think in civil side. I never thought about it on the criminal side, but it's certainly a logical conclusion. I think substantial circumstantial evidence. She was taken because she didn't get to go where she wanted to go the next day. She's not here. So all of that leads me to all of those things, and there's more, but those are the points that I highlight that to me are important for making my decision and being able to articulate for you. And I realize your position, I'm not arguing, this fact supports your conclusion as well. I just believe it's a jury issue, and I think there's sufficient evidence to let it go to the jury. So I respectfully deny your motion for the reasons previously stated. Thank you very much. All right, we'll be back at 2 o'clock, please.
Thank you, Judge.